Good morning and welcome to FirstService Residential's annual legislative update. We're going to review what went on during the 2023 legislative session. And we've got a lot of content and good panelists with us this morning to go through the legislation. My name is Tony Calici. I'm special counsel to FirstService Residential. I'm happy to be moderating today's program along with my friend and longtime legislative partner of FirstService Residential, Travis Moore of Moore Relations. Travis, good morning.
Good morning, Tony. Thank you.
The Florida legislature completed its 60-day session last Friday on May 5th. It was a busy session with updates to last year's Senate Bill 4D, which was the condo safety bill. The session addressed multifamily residential safety changes, property insurance requirements, and more. We're going to look at some of the bills that passed today. We'll also comment on one or two that didn't pass and what impact that might be going forward for your association. We will be recording today's webinar. It will be available on the FirstService Residential website in the very near future. And we will also be sharing with you our legislative alert, which reviews what's passed during this last session and some of the things we're going to discuss today. We always recommend that you consult with your community association attorney. Obviously, the changes that impact your community will vary community by community as to how broad the impact might be. So very important to engage your attorney in discussing these changes. We have a great panel today. We've got three extremely qualified, well-respected attorneys who I've had the pleasure of working with for many, many years. They are all certified specialists in condo and plan development law, and I'd like to introduce them to you briefly. First is Donna Berger of the Becker Polikoff firm. Donna, welcome.
Oh, thanks, Tony. Happy to be here.
Thank you. Thank you. Next, Marnie Dale Reagan of Gursky Reagan. Marnie, good morning.
Hi, good morning. Very happy to be back.
Thanks. And finally, Laura Manning Hudson of the Siegfried Rivera firm. Laura, good morning, and thanks for being with us.
Good morning, everybody. So,
Travis, we ready to get into it?
Absolutely. Thank you, Tony, and thank you for this panel. I'm honored to be a part of this, and thank you all for taking your time to join us today. As Tony mentioned, the session ended just last Friday, so 6 days ago. They finished up about 11 o'clock in the morning on May 5th. So you're getting information kind of just as it's becoming developed, and we're going to go through a number of bills. A lot of them are still not yet sent to the governor, so the governor still has to weigh in. We don't expect there to be a veto of any of these that I foresee. And we'll go through the ones that obviously have already become law or that have already passed the governor. Once a bill goes to the governor, just as a reminder, now that they're out of session, the governor will have 15 days to act on it. He could either sign it, veto it, or it'll become law without his signature. So real quickly, I'm just going to give you just so you can kind of get a roadmap of where we're going to be going today. I'm going to name off the bills, and then we'll launch right into to those various panelists that are going to be covering them for us. As Tony mentioned, Senate Bill 154 passed, and that's the bill that kind of fixes 4D, what passed about a year ago, last May, and was signed and became law May 27th of last year, even though a lot of those components don't take effect until December 31st of 2024. That now is the law of the land. When 154 gets signed, its effective date is immediately upon becoming law. So then that would be the new law. So we'll talk about that. It only impacts just those of you that are in HOAs. We're going to get to you, believe me. But this bill only impacts condos and cooperatives. The House Bill 919, that's your HOA bill for this year. We'll talk about that. That one, again, does not affect condos and co-ops. It just affects HOAs. When it started off, it would have affected all of you, everybody, but it got pared down significantly. Senate Bill 360 is one of those that already has been acted on by the governor that deals with construction defects and improvements to real property. Those of you that are certainly in newer associations will want to pay close attention to that. And we'll talk about how we want to kind of handle that going forward to the 2024 session, making some I think much needed tweaks there. House Bill 837 is a bill that already also signed by the governor. It passed early in the session. It's kind of the tort reform bill. There's a piece in there that does impact commercial residential or residential property and condominiums. So we want to talk, we'll highlight that for you. It's one of these things that I think you'll find interesting because it could be of help, but it also could maybe be a bit of a trap. So I think that'll be an interesting discussion as well. House Bill 437 is a bill that part of it addresses HOAs, condos, and co-ops, and that relates to flags. And the flying of flags, which is always a big deal. Seems like with associations, it's flags and pets. So, and we don't want to get those confused. You don't want to be flying your pet. But that's a bill that we'll talk about because there is a portion of that, I think, of particular interest to HOAs dealing with the storage of property. And then there's two others, 799. We'll mention it. We'll have a little brief discussion about it. It's an insurance bill, but it does make an important fix and change as it relates to condominium flood insurance requirements. And then House Bill 1383 is a bill that actually fixes something that had passed in 2021, was to take effect dealing with occupational licenses and the requirements of who can be working at your property. That many documents require certain licenses for vendors that are coming in and working as part of your community. And in July of 2023, it would have kind of preempted all of those to the state, but there's a lot of licenses that the state doesn't have a license for. So we were able to get that extended. So we'll talk about that as well. One bill I'll mention, as Tony mentioned, the one bill that I know that I'll just right off the top, there was a huge interest always for community associations, and that's vacation rentals. It's been an ongoing bill or battle in Tallahassee for the last 5 years or so. Went right up to the end of this year. I kind of really thought that they were going to get a deal done. We made sure that we had language working with these partners here, that we had language that would have protected associations, and the documents that as it relates to rental restrictions would not have been impaired or preempted. We don't think, and certainly the attorneys, that the experts that we have, subject matter experts, I don't think the legislature can do anything to impair a contract, and it is a contract, but be that as it may, we wanted to make sure language was in there that if it had passed, protected documents in 7, 18, 19, and 20 as they are now, or as could be amended in the future. But again, that did not pass, and so they'll start that again when going forward. I will just also mention that the first committee week has already been set up, and it'll be September 18th, the week of September 18th. The legislature will be back at it because next session starts January, so it'll be an earlier session. If you have any questions, little housekeeping, if you have any questions throughout the webinar, please make sure you're submitting them through the Q&A option there at the bottom of your screen on your control panel. And if we don't have the opportunity to get to all of the questions, we'll certainly try, but we'll make sure that we have somebody from the local team follow up. And as Tony said, this will get posted, and we can also post the answers. So let's jump right in with the bills, and we're going to start with Laura, and we're going to start with that bill that I mentioned made some clarifications to Senate Bill 4D, and that is Senate Bill 154. And as we go, I may jump in with a little color commentary. As somebody that was in the halls every day, I can tell you, well, the why this happened because of this, and you might find it of interest. But Laura, how does Senate Bill 154 further clarify what had passed last May in 4D?
Yeah, well, hi, thank you for having me. So yeah, Senate Bill 154 makes a lot of clarifications. We think that probably still needs some more work on a lot of those sections. But it was a 77-page bill. So there's a lot of material, but the three main areas that there were clarifications on that I'm going to talk about were the milestone inspection, the structural integrity, reserve study and with regard to budgeting and reserves. And I'm just going to highlight some of the points, that I think were important for our clients. Starting with the milestone inspection, which is the inspection of the structural systems of a building. There was clarification. That's the requirement that all buildings, condominium buildings that are over 3 stories in height, that is as determined by the Florida Building Code. I know there was some question as to how do we determine the 3 stories in height. So they've clarified that now that is as determined by the Florida Building Code. The 30-year requirement, so all buildings have to do the milestone inspection when they hit 30 years old. There was some discrepancy with the dates. If you did the math on when buildings hit 30 years old, in SB 4D, the requirement was to complete the milestone at 30 and or before December 31st, 2024. So now if the building is going to be 30 years old before July 1st, if it was 30 years old before July 1 of 2022, the deadline for the milestone is December 31 of 2024. If the building hits 30 years after July 1 of 2022, but before December 31 of 24, the milestone inspection deadline is moved to December 31 of 2025. They also clarified the provision that required the milestone at 25 years if the building was within 3 miles of the coast. So they took out that language. You had told us, Travis, that people were having a hard time determining whether they were within 3 miles of the coast. So basically now that language is gone and replaced with language that says that if the local governing body determines that you're required to have the inspection, the milestone inspection based on environmental conditions, then the milestone inspection would be done by December 31st of the year that the building becomes 25 years old. So be looking for maybe some guidance, hopefully from the local governing authorities. There were some questions before with regard to whether, if an association had previously done a 30 or 40 year inspection, and if that inspection could be used for or in place of the milestone inspection. And the legislation has now provided that, yes, it can be used so long as it was done by, a licensed engineer or architect, and it substantially complies with the requirements that are in the statute with regard to those milestone inspections. The deadline dates, there was also questions. We've been seeing a lot of issues with availability of licensed folks that are able to actually do these inspections for our clients. So we've gotten a lot of questions about whether those dates could be extended. And yes, the dates can be extended if good cause is shown and the association has a signed contract with an architect or engineer for the inspection.
Laura, if I could, I actually had a question about that. Do we know what constitutes good cause?
Basically, if the association has a contract with a vendor and the vendor cannot comply.
Okay.
That's according to the statute, but yeah, good question. The association, once the milestone inspection has been done, we're still required to comply with notice requirements to the unit owners. That's within 14 days after the association receives the milestone. They need to send it electronically, or they can post it on the website. And within 45 days after receipt of the report must be mailed to all of the owners. So those are basically the overall, some of the clarifications on the milestone inspections. Moving on to budgeting and the structural integrity reserve study. One thing that
Laura, just before you move on, we had one question come in. You mentioned a building over 3 stories, and the question was, is it 3 stories or is it over 3 stories?
It's 3 stories or more, and 3 stories as determined by the Florida Building Code. I had questions this year come up, that said, is it only where the front door is? We have doors, we're a 2-story unit, that we're a 2-unit building, but we're 3 stories, but we're 2 units, there's only 2 doors. Is that, what qualifies? So at least now we have clarification on what 3 stories is from the Florida Building Code. On the reserve items and so the structural integrity reserve study, or the SIRS that we refer to it as, kind of goes hand in hand with those budgeting with the budget issues under 718.112. Before we get to the structural integrity, one of the clarifications, we had a lot of, I know, Donna, you're going to be talking about insurance a little bit later, but one of the, we've seen a lot of our clients, suffer, I guess, or have to deal with the increased costs of insurance premiums this year. And it's been staggering. And what's happened as a result of that is we've had a lot of clients that have had to deal with unit owners challenging their budgets because the budgets have exceeded the 115% over last year's budget. So one clarification that was made in this legislative session is that when an association is determining if the budget has increased over the 115%, the insurance premium is not counted in that calculation. So that was kind of nice, because otherwise it could have been almost a gimme, right, for anybody to challenge, because those increases were so large in a lot of cases. Reserves. This is a question, I would think, aside from the milestone, we get more questions about reserves and what we can and can't waive or reduce, and how is this going to affect us. So there was some clarification on the reserve. So, and especially from those structural integrity reserve studies that, and the components in that structural integrity reserve study, there were some changes. And so previously, with those reserve studies, there were questions like, how are we ever supposed to figure out how much to reserve for a foundation, right? Or the floor. So those items have been removed from the requirements of the SIRS. And now with regard to reserves, we've got some clarification with, and specifically that items where useful life is not readily ascertainable, the association is not required to reserve. Items that are, will last more than 25 years, the association is not required to reserve for those items. However, the association is still required to reserve for deferred maintenance expenses of those items. So, they just don't have to reserve for the actual component. Welcome back.
Yeah, thank you. You were gone. Or I was gone.
You're good. All right, you're good.
My phone.
But I'm still talking. We're still moving here. So we're dealing with reserves now.
Okay.
One big change that all, condominium and co-ops should be aware of is the change in the vote to waive or reduce reserves. Is now that the vote is a majority of the total voting interests of the condominium. Previously, it was a majority of those members present at a meeting where there was a quorum. So now that's changed. There's a more stringent requirement, and that applies to all condos and co-ops, even when they're dealing with, even if they're, not required to have the SIRS study. So talking about reserves in general, the vote is a majority of the total voting interest. For budgets, now we also have clarification for when we now can no longer vote to waive or partially fund reserves. For any budgets that are adopted after December 31 of 2024, the unit owners may not vote to waive reserves for items that are in the structural integrity reserve study. So if we adopt the budget on December 30th of 2024, unit owners can still vote to waive or partially fund as long as a majority of the total voting interest vote to partially fund. And that would be the budget for the 2025 year. So that was the clarification that the budget adopted after 12/31/24, you cannot vote to waive reserves. There is an exception. That was a one kind of strange exception for a multi-condominium that operates more than 25 associations. There was an exception there. Some of the clarifications to the SERS, what is required on the SERS report. They've included the items to be included to the structure. Let me just say, they've removed, like I said before, the floor and the foundation. And the legislature has added exterior doors. So windows and exterior doors are still included. The SERS is required every 10 years after creation of the building for buildings that are 3 stories and higher, again, pursuant to as defined in the Florida Building Code. One change as to who can perform it. I mentioned before that we've seen some difficulty finding qualified folks to perform these SERS reports. So now they can be performed not only by a licensed engineer or architect, but also by a certified reserve specialist or professional reserve analyst designated by the Community Association Institute. Same thing as the milestone inspection. If the item's useful life is not readily ascertainable, not required to reserve. And finally, there's a couple of other things here, and help me out if I miss anything. The milestone inspection and the SERS may be completed at the same time. And they can be in a milestone report if it has been done within the last 5 years and it meets the requirements of the SERS, can also be used in place of the SERS. There was clarification regarding officers and directors' liability. And basically to provide that officers and directors who willfully and knowingly fail to comply with the SERS and to complete the SERS, face a breach of or basically breaching their fiduciary obligations. And I guess finally, one last, I know it's been a lot and I feel like I'm rambling, but there's so much. Is that with regard to turnover and the turnover inspection report, starting in after the SB4D was adopted, the developer was required to turn over a SERS report with turnover. And so the turnover report still must address, all of those items. They did take out some items from the SERS, but the turnover report still must address, those items such as elevators, heating and cooling, spas and swimming pools, etc. So those are just some of the main changes to what was SB4D, now out of Senate Bill 154.
Laura, I just wanted to circle back. By the way, that was an excellent summary of a very complicated bill. But in one section, you mentioned that they removed floor and foundation and added exterior doors. But there's also language in there that says reserves are only required for components for which the association has the responsibility under the declaration. So are we to assume that the exterior doors are just common element exterior doors?
I think that we can make that assumption, and that's a great clarification, because a lot of condominium documents, right, put the maintenance, repair, and replacement responsibility of windows on the unit owners. So yeah, that's a great clarification.
Right.
But I would, if the exterior doors are common elements, then
okay. That's
yeah,
what
it would only be those that are right, because there was the issue of like windows, which Laura brings up. why would the association have to be reserving for something that's not their responsibility to, replace, maintain, whatever? And so they put that language in following our argument that, okay, well, it's only things for which the association is responsible.
I think something that's concerning to me is I like seeing that they're giving a bit of an extension for if you're in process for the milestone inspections. But as a practitioner, I'm still very concerned that we don't have a lot of professionals that are coming up to bat and available to be able to perform these types of inspections and get these reports in place ahead of these deadlines. So that's still, I think, it's a problem that associations are going to have, and they need to be moving quickly on these and certainly not put themselves up against the deadlines and hope for a legislative change.
Right. I agree. And the legislature feels, there is a tsunami coming. There is a significant change in how condos have always operated. And it's coming. It will be painful when now as we're preparing for it and when it arrives. There were some things that I think were done with the Senate bill and in discussion with the House that mitigate some of that somewhat, but there's not going to be any getting around the fact that you are now going to be responsible for some maintenance and maintaining things. And just by example, the ability to waive reserves for certain non-structural items, even that change, the threshold to get that reserve vote changed from just a majority of the owners at a quorum to a majority of all unit owners. The issue, for the milestone inspections, be able to get them all done, they did put in language that says you can be part of a design team, a professional design team. The engineer himself or herself, they do not have to go to the site, but yet because they're the ones, and it's the term they use is, they still have to be the one under responsible charge. So it's still going to be under their stamp, their approval. I know that's done a lot in construction, but I think it still remains to be seen if insurers are going to be, providing insurance for an architect or engineer who's not actually looking at the thing. But that was their way of dealing with it on the milestone, and then getting enough people on the SIRS visual inspection part. It says that, that language in there that says if you're a reserve study specialist with X number of years with a certain designations, accredited by certain, well-established bodies like CAI and others, then you could also do that visual inspection. The other thing I will just note is the milestone inspection. Again, that phase one is just a visual inspection of the building. Because I've had associations tell me, well, they're charging us $47,000 and they're only going in, they're only so far into 11 units. And I'm thinking, why are they why are they going into all of these units? What are they, it's not destructive testing. It's none of that. It's just a visual inspection. And then if they say, well, hey, there's cause to think that you need to move to a phase two, that becomes a different thing. But Donna,
we've got time at the end that we're setting aside for questions and answers, but
okay.
we've gotten about 45 questions in so far on this piece of legislation. So I'd like to maybe knock off a couple of the questions that have come in. Any of our panelists are free to answer. The first couple of questions relate to the mailing of the inspection report, the milestone report, to all owners. Does it have to be by snail mail? Can it be by email? Comments?
So it just says mail, so that's regular mail, and then any owners who have consented to receive official notices by email, it can be emailed, and it can also be posted on the association's website. So another good reason to go out and get those consents for receipt of official notices by email.
Okay, great. A question on clarification of the
And
date.
it just is the executive summary. Well, Tony, I just want to say it's just the executive summary prepared by the individual doing it. And this was an issue we had last year. They were like, well, what if the association just provides an explanation? And I'm like, I don't really want, Linda, who's the secretary in Unit 2, deciding on this 100-page report what her executive summary is going to be. So it's got to be an executive summary that's prepared by the team that inspected it, that did the inspection, but that's what can be mailed out. So you're not mailing out a 100-page document. The whole thing obviously can get posted, and you should have, I mean, if an owner asks for it, you have to give it to them. But that's my comment on that.
A couple of questions requesting clarification on the deadlines, December 31, 2024, 2025, 30 years. Can we go over that again quickly?
Yeah, I can. So if the building, that's on the milestone. So I'm looking at notes here. All right. So if the building is going to be 30 years old before July 1 of 22, the deadline for the milestone is 12/31/24. If the building will be 30 years old after July 1, 22, but before 12/31/24, then the deadline for the milestone is 12/31/25.
And the reason for that, real quick, is just so that you don't have a building that turns 30 on December 1st, and then in 30 days, they have to have done a milestone. So they said, okay, for this class, for that one little class of people, as we're starting this, you can do it December 31st of 2025.
Okay, question on reserves. Do the reserves count towards the 115%?
No, they do not.
Okay, great. Where can we find a copy of the bill? Travis, myfloridasenate.gov.
Yeah, you can go to flsenate.gov, www.fl, like Florida Senate, all one word, .gov. And then at the very top, and it still has it preset for the 2023 session. All you have to do is put the number. You don't have to put SB, because all Senate bills are even number, all House bills are odd number. So if you just put 154, it'll bring it up, and then there'll be a portion of that says bill text. I also would recommend that you look at the bill analysis. I think the staff did a really, really nice job with the bill analysis on this. So that is a good document to have. But then also in the bill text, it's the very last one, the last version. That's the final version that got what's called enrolled, which means that'll be what's presented to the governor.
Just a couple of questions on waiver of reserves. Majority is defined as 50% plus one. Is it considered 51%?
Majority is majority, 50% plus one. I mean,
That's a different math calculation. 51% is different than 50% plus one person.
Right.
Okay, great. Travis, a suggestion. Somebody says turn the fan off in your office. That may help with the bandwidth problem you're having.
All right. Well, that engineer, whoever did that, could do some milestone inspections, please. All right. Yeah, I don't know what happened. It's all gone. It's gone. So it's now being connected from my computer, but from my phone as a hotspot.
Good. Let's move on. I think we'll come back. We've got a lot of questions that we haven't yet answered with respect to this piece of legislation, but we'll try to cover those at the end. I want to make sure we get through everything we do have to discuss. So Travis, we're off to House Bill 919.
Okay. Yes, and we can get back to that. And like I said, I think that's the big one. And from what I found, it's most people have questions not so much about the milestone inspection portion, but the reserve portion and the two silos now of reserves. And I'm assuming, Laura, you talked about the fact real quick about the 2 stories and below that they don't have to get a milestone. We did that.
Yes,
okay, great.
We clarified 3 stories.
And a garage counts as a story. I'm just letting you know that, because we've gotten a lot of, we have 2 habitable floors, but the bottom floor that's actually holding everything up is a parking garage. That counts. All right. So, Donna, you get to talk about the wonderful fun bill that is 919, the Homeowner Bill of Rights bill.
Great.
But
Okay.
I really can't wait So go for it.
So as you mentioned, this bill only applies to homeowners associations. It was intended to be broader, and we may see an expansion next session. But for now, everything I'm describing applies to HOAs. I think I want to start out with the one thing I'm afraid that a lot of HOAs are going to get wrong after this bill became law, which is HOA meeting notices must now contain an agenda. Okay, I'm going to say that again, because even in my own HOA, the board posts notice of the date and time and venue for the meeting, but they don't post an agenda. So I know this is going to be a big change for a lot of homeowners associations, but you have to start posting an agenda with your meeting notice. So write that down, homeowners associations. Couple different things. I'm going to go through it point by point. So a member's designated mailing address is his or her property address. That's the default, okay? Unless the member has sent a written notice to the association requesting that a different address has been used. Now, obviously, this becomes important when you're dealing with notifications, document inspection requests, and things like that. A member's email address is the one he or she provided when consenting to receiving notices electronically. Again, unless the member has sent a written notice to the association requesting that a different email address be used. Now, why is this important? Because it's a housekeeping issue, and there's so much going on. We heard Laura talk about milestone inspections and the SIRS and everything else. These little details, you know, what do they say? The devil's in the details. You have to stay on top of that. And we know that there's a lot of associations that are even self-managed. So this is yet another housekeeping issue that they're going to have to add to their list of to-do items to keep clear: the agenda and the official mailing addresses, the official email addresses. Next is security deposits. Somebody thought this was an issue. Okay, we know in a lot of homeowners associations, including ones I represent, they do take construction security deposits. A lot of times that's for impact. There's additional strain on the security. There's additional cleanup needed when you have a whole house that's been torn down, new ones going up. There could be a lot of construction debris in the roadways. So a lot of these HOAs do take a construction deposit. They also can take this security deposit for any common area damage that a tenant may cause. So this particular part of the bill says that if the homeowners association collects a deposit, and it was interesting language because it said from a member for any reason, including for expenses incurred as a result of construction on a member's parcel, such funds have to be maintained in a separate account, which they always did, and they must be returned upon completion of the construction project or other reason within 30 days. The member may request an accounting from an association with 7 days after receiving the member's request. So if a member says, hey, I want to know what you did with my deposit, the association has 7 days to respond. Now, I did make a few notes. It doesn't say that the member's request must be in writing. So who is that communicated to? If the member says that to the manager, does that count? And then does the 7-day clock start ticking? If they say it in passing to a board member who then doesn't communicate it to the rest of the board. So just bear in mind that right now it doesn't mention that request for accounting must be in writing. It also doesn't say if you return the deposit in full, do you still need to provide an accounting? If we've given you back the deposit and the member says, I want an accounting, it doesn't really address that. So those were my questions on that issue. It does get into criminal. There was an emphasis on criminal activity, which there should be. If a director or officer is charged by information or criminal indictment for the following crimes, he or she must be removed from office. It's forgery of a ballot envelope or a voting certificate used in an election, theft or embezzlement, destruction of or the refusal to allow inspection or copying of official records, and obstruction of justice. Now, I get to ask this question: what's the difference between charged by information and a criminal indictment? I am not a criminal attorney, but I know very basically that the difference is that an indictment follows charges from a grand jury's decision. So indictment involves a grand jury, information does not. Let's go on. if a criminal charge is pending against an officer or director, he or she may not be appointed or elected to the board. So they can't be removed and then their friends get them back on the board. And they may not, here's the point that I have an issue with. They may not have access to the official records of any association except pursuant to court order. Now, I want to let that sink in because I think there's a little due process problem there. So we do know people that own properties in more than one association, right? And under this new law, if they are charged, and remember, it's not convicted, it's charged with a crime, they are not entitled to get information in their other association where they own real property. So let's say they wanted to make a document inspection request in a different association for which they own property, they'd have to go to court to get a court order. I think that portion of this bill has constitutional issues. I'd love to hear from my fellow panelists if it concerns you as well.
Yeah, I mean, what if I own a condominium unit and I want to know questions about the assessment? I mean, I could be a criminal, in my, I'm on my HOA board, but yeah, I definitely see a problem there with, any association that, as that term is in the legislation.
Yeah, I guess it's any association without Florida. It's interesting language. Developer appointed directors must disclose their relationship to the developer and any conflicts of interest prior to voting on an issue. I found this one to be interesting because I think everybody in a pre-turnover community knows that developer appointed directors probably have some level of allegiance to the developer and some conflict. And even if they disclose the conflict, they're still going to go ahead and do what they want to do because they're in control of the association, which, Travis, we're going to get into that with 360. But what happens with pre-turnover communities. What else? Oh, they did make some changes regarding the fining process. So the 14-day notice prior to fining must include a description of the violation and the specific action required to cure the violation. Now, in my opinion, and again, I want to pull in my fellow panelists, I think this implies that the board may not fine for past violations, only uncured ones. It gives the owners the right to attend the fining hearing via Zoom or telephone, which I think is great. But the language that I'm questioning is the notice that goes out ahead of the fining meeting must tell you what steps you have to take to cure the violation. And then the notice afterwards also says how quickly you have to cure the violation. So in my mind, does that mean you may no longer fine for a violation that's been cured? Let me point out an example. I had a community where they had a very large party, right? Now the party was just one night, but it was hundreds of people in the community. Does that mean because that violation was cured because it no longer exists, they can't fine?
I think that there's a caveat here though, where it says if applicable. So I think that there is a caveat in the statute, and I think that associations will still be able to fine for those kinds of nuisance violations for the big parties, in the out of control.
I hope you're right.
But yeah, I mean, because there is a caveat. There is a comma and if applicable for both the notice and the after the fine has been imposed. So I think that it's still applicable. But I listen. I think it's great that now there has to be a description of the alleged violation included, and definitely the opportunity to cure where it is the violation, the type of violation that needs a cure period before the fine is imposed. So
I would just jump in and say that we need to be very careful as practitioners as well as board members that are attending. There's, Donna said the devil's in the details, and that's absolutely true because the steps with fining have changed over the years. And what you see here is you see a little bit more detail about what you need to do, which is also a requirement for details. And if you don't sufficiently do that, you've got yourself in a position to be tripped up and maybe be held liable.
Well, yeah, you risk not being able to enforce, for sure.
Right. And the other thing I want to mention is because there is an emphasis in this bill on fraudulent and fraudulent election activity. So I know my fellow panelists have seen the same thing I've seen, which sometimes there's mistakes. And which means they have to redo the entire election. They either have to push out the election date, or they have to start over from the second notice, the 14-day second notice, with different colored ballots and envelopes, because something got screwed up. It's more important than ever that you get assistance on the election materials and you do it right from the outset, because it may be a mistake, but there will certainly be somebody who believes it's not a mistake. It's an indicator of some sort of fraudulent activity. So save yourself some heartache and make sure with an election that you're getting the assistance you need.
What's something that I actually started laughing at as I read this bill is I've always joked around with my clients when they talk about, owners being induced to vote a certain way. And I say, listen, if you want to say free pizza Friday, that's up to the candidate. That's up to the person that's going to cast their ballot. The fact that it actually says food served at a rally, I started laughing when I saw that, because again, there has to be some personal responsibility of these owners. So there's a difference in bribing or harassing or inducing and merely, persuading. So
well, it's funny you say that, because it reminded me of people running for student council in junior high that said they were going to, same thing, free ice cream or whatever. But the last point I would make, I think they should have added in forgery of recall ballots. So we've seen that activity when it comes to recalls, that people are bullying, people are forging the recall ballots, people are lying about why the recall's needed. I think if you really want to attack this kind of bad behavior in an association, you have to take a 360 approach and not just believe that it's coming from one quarter. There's a lot to go around. So I think we need to tighten up and close any loopholes that allow anybody to engage in this kind of bad behavior when it comes to getting people to vote a certain way.
So the effective date of this legislation is October 1?
I believe so.
Travis?
Yeah.
Yeah, I think so.
Yes.
We had one question, is what date does the requirement to post agenda with meeting notice take effect? It's October 1st is the effective date of the statute. If a board meeting is occurring in an HOA on October 3rd, they would have to post the agenda in advance of that.
I'd start now. Get ready. It's coming. Start practicing now.
Practicing.
Yeah,
Exactly.
I was talking to an HOA board member the other day, and I said, they said, well, we just put, the sign up, like the, garage sale sign that just says, HOA meeting, and it says when and, when it is, but we don't do. And I said, well, you know what? You should probably invest in those little plastic things that they have for open houses, that the realtors use, or for sale sign. And I said, just put copies of an agenda in that and attach that to your, meeting sign. And so that when people can pull a copy of the agenda or something.
But the reality is, Travis, it's in my community too. It's in a bulletin board when you exit the community by the guardhouse. Nobody stops to read. It's this big.
Right.
Unlike a condo where you're looking at it in the elevator or, in a by the mail room. In an HOA, most people drive right by that.
Driving right by.
Yeah.
Right.
The only thing that I would add is a lot. I'm sorry. The only thing I would add is a lot of time with respect to HOAs and condos, there's certainly different laws, but I think a lot of it can pass through both. In the language that's included this year regarding conflict, I think is something that condominium owners, condominium board members, developer appointed board members should consider, because saying, hey, by the way, I represent the developer is never a bad idea. It doesn't preclude you from voting, but then it makes it really easy going forward to say, but I told you so, you knew. And I think it's just a good safety measure to have. It doesn't preclude you from voting, but it really can push off a lot of those arguments you get from your members that maybe you shouldn't have voted, which you do.
I agreed. This is one of those issues that we talk about it every year, where there is, where you have policy that's trying to fix bad actors, but the way, they go at it with a very big hammer, because they have to, it impacts every association and it impacts every board member. And so, the argument also was always been that we end up with is, HOAs are different than condos, are treated differently by there is no state oversight in the same way. And so there, we're left with just, criminal activity. And so this was an attempt to take care of bad actors. But again, I think as Donna pointed out, there's some 360 thinking that needs to happen here to get this right. And I think that I know for a fact that they'll be coming back at this because sponsors of this legislation were not pleased that certainly in the House, they didn't get some language that they wanted where fines could not become liens. They wanted there to be some criminal charges instead of some civil charges for things like, records, et cetera. And there was pushback certainly in the Senate on that. So they'll be back looking at this kind of thing. As originally filed, like we said at the outset, this affected everybody. It was about a 60-page bill. It's now down to about 16 pages, but it had, got rid of DVPR being the place to go. And it basically had FDLE, the Florida Department of Law Enforcement, as the place to go. And it was where they had subpoena power. They could come in, and it was very aggressive. Yet none of us want criminal activity occurring, certainly in our neighborhoods or anywhere. But that really went kind of beyond. So this is something that it passed in a much mitigated manner. I think, as Donna said, get ready for it. It's coming. And then we'll be working on, I know, going forward, keeping some additional things from happening, but also making this actually work a little better. So, Tony, if there were no questions on that, I think we can move to the next.
There's a lot of questions, Travis, but we'll
okay.
We'll put them off to the end. At this point,
okay.
I want to make sure we do, go through all of the different bills that we want to comment on.
Right.
I think Donna's up next again with.
I'm in the hot seat again. Okay.
Hot seat again.
Yeah. You got her water.
360. What can you tell us about Senate Bill 360, Donna?
Okay, so Tony, this bill was signed by the governor and it's already law. It became law on April 13th. And it's going to impact both new construction and renovation and repair projects, which is important. So if you thought you could tune out on 360 because you're a long established community, you can't, because right now, getting back to Laura's summary of 154, many of you are going to find that you have to undertake repair projects when you get the results of your milestone inspection. And many people are doing that already right now. So 360 does a couple significant things. It made changes to section 95.11 subsection 3 of the Florida statutes by reducing the statute of repose from 10 to 7 years. And that is that's the longest you have to bring a claim for latent or hidden construction defects. Now, it's important to remember that once upon a time in Florida, the statute of repose was 15 years. Then it went to 10 years. Now we're down to 7 years. Does anyone see a pattern here? Okay, this is an extremely strange bill to happen in a session that's only 2 years out from the Surfside tragedy, when we've had an emphasis on condos in multifamily safety. So we've said to boards, hey, you've got to do routine engineering, you've got to pay for it, you've got to fund reserves so you have the money for the repairs that are going to flow from those inspections, right? But on the other hand, we get SB 360 that is making it harder, that's shaving years off of an association's ability or an owner's ability to pursue a developer or a contractor for defective construction. So let's talk about the new law. Also starts the deadline clock running earlier. So it's not just the fact that they shaved 3 years off the statute of limitations, but they've also started the clock running earlier. So previously the triggering events were the later of certain occurrences, and now the clock starts running at the earlier of certain occurrences. And that includes a temporary TCO, which is a temporary certificate of occupancy, a certificate of occupancy, a certificate of completion, which is typically for roads, sidewalks, and drainage, or the date of abandonment of the project. So let that sink in. Temporary CO, a TCO, that could start the clock running on 7 years for a hidden or latent defect. We're not talking about something that's open and obvious. We're talking, and this happens a lot with concrete restoration, you may not find out for quite some time that that has not been done correctly. Here's another huge change. the statute of limitation now begins to run on a per building basis, not when the whole community is completed. So if you're listening to us and in your condo community or cooperative community, you have multiple buildings. In the past, it would be when the whole project was completed, right? When all the buildings were completed, developer was done, statute of limitations started to run. Now the statute of limitations will begin on a per building basis. So if a community is constructed over many years, then claims may be time barred with regard to certain buildings before it even turns over from developer control. It adds, and I want that to sink in. You could be out of time to file a complaint for a construction defect before you even take over control of your association. And I think my fellow panelists are going to agree, safe buildings start with the people who build them and the people who repair them. So I don't know what we're doing here. I don't know why, on the one hand, we are rightfully emphasizing building safety, and on the other hand, we're undermining an association's ability to make sure the building's safe because they paid for a certain level of construction. The other thing this bill does is it adds a materiality requirement for an owner or an association to bring a private cause of action for violations of the Florida Building Code. Now, the Florida Building Code is the minimum level of building standards. You can certainly build higher, but that's the minimum level. So you must now show that the violation will result in physical harm to a person or significant damage to the building. I will say that there's a savings clause in the bill, which provides that any cause of action that existed before SB 360 passed must be filed by July 1st, 2024, if it's still viable under the prior 10-year deadline. So the takeaway from all of this is, I think we need to do a much better job of communicating with our legislators that if they really have a commitment to building safety in Florida, they cannot pass bills like this. They have to give associations time to pursue their rights. And this was, of course, passed under the tort reform that everything's so expensive because lawyers sue. But, you got 3 lawyers sitting, actually, you got 4 lawyers sitting on this panel. I'm going to include you in this, Tony, that, we know that there's some bad actors, of course, but at the end of the day, the answer is not to rip away consumer protections. We still have issues with builders who build defective products. So,
right, it almost seems like the builders take the position like they could never do anything wrong.
right.
We don't build buildings with defects.
Right. And Laura, I asked that question of an engineer I had on my podcast. I said, how do we ever have building defects if everything's being inspected by the local building department, right? And the answer was, you've got a local building official, who will go every, 10 days for 30 minutes sometimes. So they're not catching the local building department is not catching all the defects as the repair work is being done or the new construction's going up. I'm sorry, Marnie.
Well, I was going to say, actually, a different thing now. You add that to the effect that your local building departments are going to be so much more involved in the milestone inspections and all of those processes. How are they going to be looking at new construction, restoration work, and be able to keep up with all of it? So I think it's difficult. And I don't honestly don't know that they're funded to do so.
The developers were arguing, we can't get insurance for this construction trades because nobody's giving us insurance, or our insurance is going up. And I'm like, well, association's insurance is also going up. And as Donna said, I said it literally doesn't make any sense, within 48 months or less than with a building that we are pretty sure had some significant latent design flaws. And these are things that take time to show up. And so we do have some commitments going forward to really take a look at this and at least make the trigger for condo associations and for the common interest, common elements of an HOA, like a clubhouse and et cetera, to make it when the trigger would be at turnover. Because like for a condo, I believe, and the lawyers can correct me, I think turnover doesn't have to happen for 7 years, which ironically or not ironically, is the same date as this. It can be triggered earlier if there's 90% of the sales or whatever that could trigger it having to start the process earlier. But the developer's in
But you could
control
pump the brakes
of the
on
board.
that. Right.
Right, and they are in control of the sales, so they could
Yeah.
say, "Hey, we're getting it. We're at 80%. You know what? Let's back off a bit here of sales. The bill. I mean, you know what I mean? And so we really think that at the very least, the turnover, because the association has no standing until turnover, because a board that's controlled by the developer isn't going to bring a suit against themselves for
Right.
a claim.
And that, yeah. There's a Supreme Court case directly on that point, that, the association cannot bring a claim for construction defects until after turnover. So how is that going to jive with this, statute if the developer has pumped the brakes, right, on the closings and the sales and the closings? And, 7 years from TCO has come and gone before we get to turnover. Now we have this Supreme Court case that says the association can't bring the claim anyway until after turnover. So,
oops, Charlotte. Well, let's circle back to 919, the Homeowners Association Bill of Rights. That bill originally had language that said they couldn't use association funds to litigate. That was language that was in there originally, that they couldn't use association funds to bring a lawsuit, and there was no exception for a construction defect suit.
Right. Yeah. So you couldn't, even then the associations after turnover, our hands are tied. And this isn't for, and I think, Donna, you bring a good point, and just in passing, you mentioned, which I think is important. This isn't just for a new association. This is also for all of this construction work that's going to be done when you do a milestone inspection and somebody says, you need $1.2 million worth of concrete restoration work. I mean, unless I'm wrong, that's a construction, property improvement that they're doing. Could that also mean then that, okay, the clock has started on this, because to me that 7 years just doesn't.
Well, in the worst case scenario, we've got people right now who are worried, and justifiably so, that they cannot pay these special assessments that are coming. We're seeing assessments 20, 30, 40, 50,000 plus per unit on deferred maintenance. So it's one thing to scramble and have to come up with the money to pay the special assessment. But a worst case scenario is you take that money, you hire a contractor who delivers a defective product, and now we've taken away your right. We find out about it years later. Now we have to go back to the same group of people and specially assess them again. It's just not right.
Right. Yeah, no, it's right. So that is a high priority for us next year.
One of the questions
I think Tony
was addressed in the comments was, this is not condo specific. It applies across
the board.
Yep. Okay.
Right. And HOA developments go, I mean, they can go way long. They do phases and phases. So next, there's another bill like this one, while we're talking about bills that have already passed and been signed. Another bill, 837, was passed, as I mentioned, at the very beginning of session. It was in March, already signed by the governor, already effective, and that deals with tort reform and kind of overhauling Florida's litigation landscape. So, Marnie, can you explain or discuss, just, when we think, oh, tort reform, okay, that's not anything we have to pay attention to. Why would this be important for associations?
Exactly. And as you said, this passed back March 24th. So it is law now. And this is kind of what I call like the lawyer's bill. It has to do a lot with attorney's fees and negligence and all those things that nobody wants to think about, but we all have to deal with. As association board members, I think a lot of times you see these things come through as the association got sued, and you can add, again, or not, you pass it on to insurance defends. So what we're seeing here that I think is pretty interesting is there's a real thrust that if someone is comparatively negligent, they're going to be limited in their ability to recover. And I think that's actually a nice step in the right direction. If you're found to be 50% negligent, you can't recover from a tortfeasor. I think that's fantastic. There's interest in altering the way bad faith is dealt with insurance claims. If your insurance company wants to deny you typically would discuss with counsel, maybe bring in a bad faith claim. But if they've tendered their policy limits, that really can change that playing field as well. So I think it really will induce insurers to act appropriately and have a true fair dealing, which I think we need to see across the board. There's alterations in the statute of limitations for some negligence cases from 4 years down to 2. So, as board members and residents, if you see something where, John down the street just filed a lawsuit and this happened forever ago, there's going to be a little bit more of a timing issue, which I think is going to help associations in that we have our records, we're bound to keep our records, but maybe we have a little bit more historical knowledge going forward as to what actually occurred. And maybe hopefully some of the players that were in place when it happened are still there. So I think those are all steps in the right direction. But there's an interesting component at the end of this bill that deals with premises liability. Initially, everyone's fault is going to have to be considered. So if someone were to leave their windows open, they're going to be found at fault with a criminal act. And I think, again, personal responsibility. And there's no issues with going after individuals when they've done wrong. But this inability to take any responsibility whatsoever, I think needs to be brought back to a kind of a reasonable nature. But where this really comes into our dealings here today, and with respect to condominiums, is this new crime prevention through environmental design. And I think it's a neat theory. We're going to see how it is really in practice. There's components that an association is supposed to put into place if you have more than 5 units. So if you're under 5, you're good to go. But if you're 5 or more, you're going to be having to think about this and having to think about this pretty concurrently with now. So there's a list of items that every association should put into place. And if you do this, there's going to be a presumption that you did not act negligently, that you can avoid liability. The first is going to be security cameras. They need to be points of entry and exit, and they need to have a 30-day loop. A lot of associations already have this, but make sure that you comply with this provision in that it's facing towards entry and exits. You have to have a lit parking lot. There's the lumens are actually discussed, and it says the 1.8-foot candles. You need to also have lighting in your walkways, your laundry rooms, your common areas, your porches. That light has to be on from dusk until dawn. There has to be electronic sensors for that. Now, that seems very common sense. Now, here's where it is going to get more difficult. And actually what it reminds me of is it reminds me about 10 years ago when all of a sudden unit owners had to have insurance. And we started force placing insurance and having to deal with enforcement. And this is where this makes me think of that. Because now we're requiring a 1-inch deadbolt for every unit door. We have to have a locking device on every window, every slider, and any other door that's not a communal door. Those two to me are I think would be an enforcement issue, because as much as it would be common sense, hey, let's put locks on the door, let's put a deadbolt in. You have an absentee owner, or you have an owner who's renting and they don't want to put in those extra safeguards. I don't want to say that you've got a teenage child who's Jimmy the lock, but that's a possibility. These are going to be enforcement scenarios that the association is going to have to look at to determine compliance, because again, we want to have this ability to protect the association from this liability for a criminal act, but we're requiring our owners to take these actions. And where do you get the big brother of the association is going to do this for you, or we're going to insure, and or we're going to check on a regular basis? So those items within that list of 7 are a little bit more problematic for me. The next item that you have is again, to me, pretty easy. You have to have a lock gate along your pool, or you have a fence around your pool. Going back to my problematic ones, though, is a peephole or a door viewer, which something interesting to me that this bill doesn't really contemplate at all is if we are going to require these peepholes or a door viewer, is it a material alteration? Are we going to invoke our owners having to approve these types of things in order to hopefully avoid this liability? Again, a common sense would be, no, it's a safety, it's a health, safety, welfare measure, but it's not clear through here. Now, I discuss these issues, but what to me is going to be the troubling and very interesting fact for boards, owners, and management is how this is going to be undertaken. The bill talks about substantial compliance. So we have a list of 7 items. Say all 7 could apply to you. Are you substantially compliant if you've done 4, 5, 6? Do you have to do all 7? And then how do we go about doing this? As of January 1st, 2025, we're going to have to put together this crime prevention through environmental design assessment and have a report. There was actually a body that I'd never heard before. You can have the Florida Crime Prevention through Environmental Design practitioner work with the Florida Crime Prevention Training Institute of the Department of Legal Affairs to put together a plan for you. Then you have to implement the plan. So many management companies have language in there, and rightfully so, that they're not a guarantor of security, that you want to engage security companies to do these things for you. Employees are going to have to be trained. They have to be trained within 60 days as to your specific plan. So who's going to do that training? You can have law enforcement come out and train. And again, we're talking about substantial compliance. So we want to have all these measures in place, and it's certainly a great idea. But I think the implementation of this is going to be curious, to say the least. I don't know if this is going to create kind of a cottage industry of individuals who are going to put together this curriculum, do this training, do these protocols, prepare these reports, and walk the property with them. Again, at the end of the day, the burden is going to be on the owner, the association, in order to state that they've satisfied all these requirements, the substantial compliance, in order to try to avoid this liability. And again, what we're talking about is a criminal act by someone against either a resident or an owner or a third party who's rightfully on the property. So I think it's a very well-intended bill, but the practice of it's going to be a touch interesting. And I'm curious to hear what the other panelists have to think about the enforceability, the alteration component, and how it's really going to be.
The alterations for security cameras and lighting, Marnie. So typically we say, look, if you're having a criminal, issue in the community, you've had law enforcement come out, they've done a security assessment, then you may be able to go ahead and install these items because you're already having an issue. But just to be proactive, you don't have any criminal activity, nothing's really happening. It's a big question. Can we install security cameras without a material alteration vote? Because that's a material alteration. Same thing with the lighting, same thing with, a lock at the, the gate at the pool. All of that typically is a material alteration. So I think they're going to need a legal opinion before doing it. I did have to me, you don't have to do any of this stuff if you're not worried about getting sued. So I think we need to tell them. It's not like somebody's going to come around and say you have to do all this stuff. You don't have to do any of it. And if you don't have any criminal activity, you're probably okay. But, if you want to be proactive and take those steps, then that's a possibility. I did have one question for Travis. Travis, there was language inserted in this bill that said that it's 5 units, as Marnie said, but the condo has to have a distinct parcel ID number assigned to it. That may not apply to all condominiums. Any idea why that language was stuck in this bill?
No, I don't. This originally was being done for or contemplating the apartments, apartment complexes, not condos, and it was in response to a case where there was criminal activity, and then maybe some kind of an assault, and there was liability because the apartment owners should have known better and didn't provide proper secure environment. So then when they decided to kind of expand it a little bit at the end into condos, it was to try to, like you said, provide them with a way that they could avail themselves of the immunity section of this. But it becomes like this slippery trap, maybe, where it says, well, if you don't do it, are you then in fact, if you do it, yes, okay, you can avoid liability, but if you don't do it, are you liable? But I don't know why they came up with that
parcel. I guess the point I want to leave
magic
is
number of 5.
get a legal opinion, because if you don't have a distinct parcel ID number, this is not going to be for you. So when you're starting to do this, reach out to counsel, have title search run, and make sure this is even applicable to your condo. Because I know some condos in Port St. Lucie, this is not going to apply.
Right. Yeah,
Something else I
because not
wonder
all,
about, though.
not all condos have them. I'm sorry, what?
Sorry, Joe. Well, something else I was thinking about as I read this is, is that, yes, it's permissive. But are we going to see a shift where insurance carriers are going to start requiring that we have compliance in order to provide coverage? Or is there going to be a benefit or a bonus to the policies that are available? I just kind of see the ripple effect going down the road from this.
I've yet to see a benefit or bonus.
I agree.
Yeah, I think it's going to be, I do think we'll start to see language, put in where there could possibly be exemptions. Now, again, this is not for civil, slip and fall kind of things. This is for criminal activity. This whole section only is dealing with criminal activity, but I don't think, and I don't know, do you guys would know if a policy, typically if an insurance policy even covers the association, like their exposure, if there is criminal activity on their property and they're deemed
Well,
to be.
yeah, I mean, we've seen insurance policies definitely cover the defense of our association clients when, there is a criminal act that occurs on a common element, that actor maybe is a complete third party, right? Not an owner or anything, but, sometimes stuff happens, right? In a parking garage, if there's rape, sometimes it happens and the victim, ends up suing the association on a negligent security claim. And there has been coverage. So some associations, there, at least in my experience, there used to be coverage available for, those types of, injury claims or negligent security claims. I think the takeaway, even if it doesn't apply, because there's no harm in taking security measures or measures to, make your common areas more safe for anybody who's living there, whether it's the lighting in the garage, right, or the parking areas and, security cameras if you've got them. No harm, no foul there in taking those additional measures to enhance the safety of your residents. So.
Okay.
Tony,
Yes.
do you want to, I didn't know if there were questions there, or again, if we just wait to the end.
We're going to wait to the end. I've been, answering some of them as I can, but we'll take them at the end. Laura, House Bill 437. What can you tell us about that?
So House Bill 437 applies to homeowners associations, and it does three things basically in Chapter 720. So one, it allows unit owners to have two flags now instead of one previously. Two, it enlarges or adds to the types of flags that could be flown. So previously, the United States flag and the official state of Florida flag and the flags that represent any of the armed services and the POW/MIA flag were the only, flags that were authorized, notwithstanding any restrictions that may have been included in the association's governing documents. But now unit owners may also fly first responder flags, and those first responder flags include, a flag that recognizes law enforcement officers, firefighters, paramedics, correctional officers, 911, public safety, telecommunicators, registered nurses, people that participate in statewide urban search and rescue programs, and federal law enforcement officers. So they've expanded the scope of the types of flags that may be flown, notwithstanding any restrictions in the covenants. And then HB 437 has added a new section to 720. It's 720.3045. And this one is interesting because this one states that installation, display, and storage of items. This has to do with installation, display, and storage of items on the exterior of property. And what it says is that regardless of any covenants, restrictions, bylaws, rules, or requirements of the association, and unless prohibited by local law or local ordinance, an association may not restrict parcel owners or their tenants from installing, displaying, or storing any items on a parcel which are not visible from the parcel's frontage or an adjacent parcel, including but not limited to artificial turf, boats, flags, and recreational vehicles. So we've had a lot of discussion on this in our practice session. This came up in an issue I was dealing with yesterday for a townhome HOA association. I think that there's going to be, I think there needs to be a lot of clarification here, because it's notwithstanding any of the restrictions in the covenants, an association may not restrict parcel owners from installing items on a parcel that are not visible from the front or the adjacent side. So we were dealing with a townhome association yesterday. The owner had installed, a piece of equipment that had to go through the wall, the exterior wall of the building. Well, that exterior wall of the building, it's the association's responsibility. It's not considered a part of the unit. And, if this bill, when this bill, takes effect on July 1 of 23, is this now telling our associations that we can no longer enforce that restriction? There's no clarification in this language. So I think we're going to be, I think this is going to create a lot of problems. It's probably going to create a lot of problems for certain associations, and then it's going to take a lot of wind out of the sails of a lot of associations and their enforcement abilities with regard to modifications that are made. Because it's one thing, display and store, items is one issue, but this actually talks about installing an item. So does that mean construction? Is that because this installation, this was a piece of equipment we were dealing with yesterday, but does that mean, what if I pour a concrete slab patio on the side of the property? Does it affect the construction? I mean, that's an exterior modification, but I don't know if that qualifies as an installation or is it an item? But to be determined. I think this this one leaves a lot of questions.
I have so many questions.
Yeah,
I have so many. What about a golf course community where you've got, and let's say the golf course has merged, so it's common element, that's common area golf course, so you can put anything. A lot of those communities do place restrictions aesthetically because you've got people enjoying the golf course. So now we can have the shed next to the trampoline, so there's that issue, aesthetics. I have a community where the homes back into a protected conservation area, where there is a covenant in the declaration that says you can't put anything in that area, no structures, no installations. You can't even have invasive plant species. And that is via a restrictive covenant that the South Florida Water Management District insisted upon. But as Laura said, it's general law or ordinance. So that's not a restriction under general law or ordinance. It's under a private covenant in the declaration. Does that now mean that the homeowners association cannot enforce that, and therefore is going to be in violation of the restrictive covenant with South Florida Water Management?
I think it's going to depend on if it can be. Well, I have some stories about this whole thing, but I think to that point it's going to be determined by this: is it visible from an adjacent parcel?
Well, not for my example. My example is a protected conservation area.
Yeah. That even may be. That's another wrinkle that I don't think any of them even contemplated. So number one on this bill, the flag issue applies to both condos and HOAs. And the funny thing about the flag thing is I'm sitting there in this committee and we're dealing with this bill, and because he was there for another bill, a gentleman who represents the first responders, association said, "Why are we in this?" And I said, I have no idea. And he said, "Well, we don't have a flag." And I said, "Well, this could now be a moneymaker for the association. By God, go design yourself a flag." He goes, "What is it? Somebody with like a headset? Like, I don't know what is a 911 operator flag even going to look like?" So they don't even have a flag, but they're in there as one of your choices. On the storage thing. So this bill started off as just a flag bill. It was an act relating to the display of flags. We have issues just in general, making sure that with flags, we're all trying to create harmonious communities. Flags, as we all know, have kind of become political signage issues, and where do you kind of stop it? And it becomes this whole thing. So we were like, you know what, we're not going to fight the flag thing. It's fine if it's just a flag. So then all of a sudden the bill, morphed into this, an act relating to displaying of flags or the storage issue. So I go to the sponsors and I'm like, why are we dealing with what's the storage issue? And the story was that there was a high-end community where there was this on the water, where there was a gentleman who had been told that he could not put in artificial turf. He was a donor of a legislator or legislators, and he decided, well, I'm going to put it anyway in the backyard, so it can't be seen by the front yard, so I'm good to go. Well, because he's on the water, somebody saw it and said, "You're not allowed to have that." Kind of turned him in to the association manager, somebody. And then he ran, to his legislators to say, I want this fixed. And so upon hearing this story, I said, well, look, you got things in there with boats and ATVs and all kinds of stuff. I can get you language to just deal. I don't like it, but I can deal just with your artificial turf on the water problem. Like, I can this problem very narrowly. And the legislator said, and so I gave him the language, and then I came back the next day. What do you think? And the legislators were like, no, our problem here in Tallahassee is we deal with things, real specifically, but we're not dealing with the overall issue. And the overall issue is you should be able to do whatever you want on your property. And I said, well, not if you've signed an agreement, a contract that says I'm giving up some of my rights on my property because of the benefit that I get to have a community such as where I'm in. And he's, the argument was, nope, if it can't be seen by your neighbors, if it's your own thing, you should be able to do it. So this is why we have the language we have. I mean, there's literally a story about it on every bill, but that's why we have this. I totally agree, Donna, that this needs to be just like construction defect. This has got to be one of those things that we make a high priority that we have to deal with, because it starts to undermine the whole concept of common interest ownership and what you've agreed to do and abide by. Plus, I also think we're going to end up with a whole bunch of people running around saying, aha, I can see, it's poking out. I could see your boat, and then what are we going to deal with? I mean, is there fines? Then it starts to deal with the stuff that they're saying, well, we don't want people fining in HOAs. So I just think this is a mess and it needs to be fixed, but that's why we are where we are. I'll leave it at that.
So we've got a few questions that we can knock off quickly on this, I think. First is, so I can fly 2 flags from the balcony of my condo from its railings with rope. Well, this is HOA specific. We already had flag language in the Condo Act, but in terms of a condo owner flying flags from his balcony.
So no. So the act addresses condominiums, but only to add the
Right.
types of flags that a condominium owner may fly. So condominium, it's still one flag, and it's still, Armed Forces Memorial Day. The new flag is the Patriot Day flag that may be flown by a condo owner. So condos still only one flag that can be flown. The two flags is a change to the Homeowners Association Act 720.304.
And Tony, flags must be flown in a respectful manner. I don't know what flying a flag by rope means, but that may or may not qualify as respectful.
A question related to the timing, am I restricted as to time? Well, there's specific dates that are listed that are allowed in the statute. And presumably that would mean, midnight to midnight, those specific dates covered.
I think it also goes back to the respecting and respectfully flown when you can fly flags, especially with the American flag.
I think you need a light at night. I think there's certain days under, in terms of what you're celebrating, but yes, respectful. If you're going to fly it at night, it needs a light, I believe.
But there's no timing on the, may still display the flag not larger than 4.5 by 6 feet. And, if you're flying the United States flag in your HOA, there's no time requirements for it. This act is not, a lot of times we see in covenants, flag rules and HOAs flag rules when people can put up their, Christmas or their Hanukkah or their holiday, whatever their decorations, and there's specific time periods, but no, there's no time periods in the with regard to display of these allowed flags, notwithstanding, any covenant restrictions.
Right, and there's also some confusion because what they were trying to do for Patriot Day was the 9/11 Memorial Day. So like on September 11th. But technically there's also a Patriots Day, different type of flag, but Patriots Day is the one in Massachusetts, essentially, that is for the Boston Marathon issue, which is like, the third Monday of April or something, or April 17th or whenever the Boston Marathon is. So because of the Boston Marathon bombing, so they have and then, remember the movie Patriots Day or whatever. So there's some confusion there because because I was there when they were debating this, what they deem as Patriot Day is 9/11, not whatever's happening in April regarding that. So that makes it even more confusing, even the parts that aren't supposed to be confusing. But there you go.
All right, we've got
was there another question there, Tony?
There's a bunch, Travis, but I think let's cover the remaining bills that we wanted to comment on, and then we'll come back to as many questions as we can before the end of the session.
Okay, and then so that takes us back to Donna for House Bill 799, which is a property insurance bill. I think our main issue would be as it relates to flood insurance. So do you want to walk us through that briefly?
Yeah, briefly. I mean, listen, I think citizens recognize that there's going to be a lot of people that aren't going to be able to afford their assessments when their assessments include these huge insurance increases. Citizens basically is doing what the legislature did not do, which is be more receptive to older roofs. I referred to them in our practice session as the Medicare of the insurance industry. But basically, this law stands for the premise that HO6 policyholders, which are the individual condominium unit owners, do not need to purchase flood insurance because the association's master policy, if they have flood, covers the units for $250,000 per unit, which we just saw happen with Ian. What else? The bill does require personal lines residential policyholders to have flood insurance if their structure has a dwelling replacement cost of $600,000 or more on January 1st, 24, for a structure of $500,000 or more on January 1st, 2025, and $400,000 or more by January 1st, 2026. And then by 2027, they want all of the HO3 policyholders to have flood insurance. So the other thing the bill does is it says an insurer may not deny a wind claim because the insured does not have flood coverage unless the insurer verified that the insured had such flood coverage at the time they issued the wind policy, but then the insured failed to have flood coverage in place at the time of the loss. So I think the takeaway for our condo owners listening is that they don't need to have flood insurance coverage because it's covered by the association's flood policy. But again, not a bad idea to have it. You know, it's always a great idea to be
Yeah, and
proactive on these things.
And this was that whole issue that, you know, like Senator Pizzo and others were saying, why do I, as a condo owner on the 40th floor, have to have something to cover, you know, for rising waters? This is a policy I'll never use. Plus, as Don, as you point out, unlike your typical property and casualty master policy, a flood policy does provide for unit owner coverage up to that 250. So, you know, if you're in the lower floors, or certainly, you know, your policy is already going to cover it if you're in that flood zone. And most, if you're in that flood area, have a master flood policy. So that is that. Thank you, Donna. And then a couple more, just 1383, Laura, that deals with occupational licenses. You want to mention that real quick?
Yeah, briefly, basically, the legislature has expanded the ability of specific contractors to get specialty licensing. So this was like screen enclosure, vendors that do screen enclosures, marine seawall work, any marine docks or pile driving, structural masonry, solar, rooftop solar heating installers, structural steel. I would think that one is not, would be a requirement anyways. Window and door installation, and including garage door installation, plaster and lath, and structural carpentry. So those are some of the categories that have been created for specialty licensing. But so contractors, these specific contractors, they're able to now get these special licenses, but at the same time now local governments cannot require that these specific these types of contractors obtain these specialty licenses. So just because they're available for them to obtain, local governments are prohibited from requiring that licensure for work where a permit for those jobs is required. So
right, and that's all part of legislation that passed in 2021, where they were preempting all occupational licenses to the state. And then DBPR is like, well, we don't. I mean, there's certain specialty we don't license people that work on seawalls, or docks. We don't do that. And so local governments, if you're in Fort Lauderdale, I'm assuming the city, city or Broward County is going to be requiring, there's an occupational license for that. So that change was supposed to take effect July 1 of 2023. So just in a couple of months. Basically, in this bill, we were not able to get to the fix of the issue of not preempting all of this to the state when there are no, as you discussed, Laura, where there are no state licenses. So basically, we just changed the effective date. This is kind of like the Donna Berger kicking the fire retro sprinkler fit down the road a year. So what we did was, because we couldn't fix it, we just said, well, this doesn't take effect until July 1 of 2024 to give us another year to try to actually get to the issue. If that makes any sense. So, and then as I mentioned, the 14, which was vacation bill for this year, did not pass. So we don't have to spend a whole lot of time on that. It did not pass. It'll probably be back. It always is. And we'll be on top of that. So Tony, back to you.
Yeah, Travis, there were just a couple other legislative enactments related to COVID-19 mandates. Senate Bill 252, anything in particular our associations need to be aware of there?
Well, and I'll let the panel briefly speak of this. It was an effort to say essentially for businesses, you cannot require like a mask mandate for these businesses. Well, the next, if there's another COVID-20 or whatever the next thing is, does that in fact apply to condos, which are corporations, but they're not for-profit corporations and they're not businesses? I'm not sure it applies. If we decided, well, you need to require masks for, say, a meeting or whatever, the gym to that point. But Donna, do you have thoughts on that?
I mean, I think you raised all the questions I have too. Again, it pertains to business entities, and I don't know that we would classify private residential communities as a business entity. I guess we'll see what happens.
Right. Well, unless
or hopefully we don't.
Unless you're at Celebration.
You're right. Hopefully this has never become an issue.
Right. Unless you're at Celebration. If you're a community at Celebration, we have a whole nother section for you. Get your monorail inspected.
I do think something that's kind of interesting about this is, I understand the desire to not have the mandates, but health, safety, welfare comes into play quite a bit. And if we had another pandemic, we do have items that have already been drafted into the statutes that may surpass this one bill. So,
Right.
And to that point, Laura, since, post 2020, 2021, a lot of communities have amended their governing documents to empower the board to pass those kind of safety regulations. So,
Right. And,
now
right.
you would
And
have
then
a
that becomes a
constitutional
contract.
Yeah.
And then something that's I think it's unfortunate given the day, the age and where we are related to society, we're dealing with a lot of folks, more so I think I've heard more about it recently than late, that are just struggling with some issues. And so they did pass a bill regarding regarding the Baker Act, which was 829, which could, again, this is one of these very, tangentially could affect associations, but panel, Donna, others, do you have some thoughts on that?
Yeah, I do. I mean, listen, May is Mental Health Awareness Month. So this is timely this month that we're, that we're addressing this. And I think, correct me if I'm wrong, but isn't that that statute is basically delegating to the administrative agency to come up with a protocol for how to deal with or how to implement the Baker Act. And, we've seen, I know personally since, the COVID-19, my clients have definitely seen an uptick in mental health issues with residents, and the Baker Act, we get asked frequently, does this person need to be Baker Acted? That's not something that I can determine. I always leave it to the other authorities to do that. But, if this is going to be a guideline for when and how Baker Act is implemented, I think, it will, hopefully it helps and provides some guidance.
Agreed.
Travis,
Yeah, more information is better.
I'm sorry, I just wanted to pop in because I know we're running out of time, but Laura talked about occupational licenses. You talked about vacation rentals. The state has tried to, there's a preemption trend that has been going on for a few years here. And I just wanted to pick your brain really quickly. Are we going to see any sort of reversal, or is it more and more going to be the state of Florida trying to preempt local government from tackling some of these issues where we're going to have to look to the state for everything?
I do not see an end to that trend. I think it might slow a bit. I think, certainly the current administration is, they basically want, I would preempt the legislature if they could, but, the legislature become like an executive branch agency. But I think we could see some of it slowed, but some of the things that I'm seeing, as it relates to school boards, as it relates to them getting involved, even just, university hiring, dealing with all kinds of things. You know, it is seemingly become this Tallahassee knows best mentality. And you know, we fight all the time or struggle or try to educate and advocate for, you know, associations are all different. They're in unique neighborhoods. They're in unique places. They're very different. They know best. You know, it used to be, and we still feel this way as it relates to associations, that, you know, the government closest to the people is the best. And let's not continue this trend. But I don't see it abating soon. I think that they, you know, but the legislature doesn't like it when the federal government to them, you know, then they say, whoa, we know better here in Florida. What are you doing? But so that's just my observation.
All right,
Tony, back to you.
panelists.
Get our questions.
We're about to enter our lightning round. So we've got about 10 minutes. We had over 100 questions asked, and we've answered roughly a third of them. So we're going to go back, and if the panelists, if you can click on your toolbar down below, and you'll see the questions. We'll kind of start at the beginning, and just whoever wants to answer. We'll go through as many of them as we can in the time we have left. So the first one, we have 15 three-story buildings in our complex. Is the reserve requirement for all buildings or each building?
Is that so?
But that's all right.
I mean, if they're a multi-condominium association, then each building is required to have its own budget and its own reserves. So, you know, depending on how you are structured, the reserves could be, you know, either for each condominium or for each building or for the entire set. It just depends on how you're actually legally set up.
Great.
I'll take the second one, Tony. Nothing with a useful life of 25 plus years needs to be reserved for. That takes out generators, railings, elevators, etc. That's a huge difference. Am I misunderstanding this? You still need to reserve for deferred maintenance. The bill says that you don't have to reserve for replacement costs for those items that have a useful life that exceeds 25 years, but you're still going to have to reserve for deferred maintenance.
Great.
Right. So like load bearing walls, you know, they're supposed to last, you know, forever kind of thing. When you get your structural integrity reserve study report, it's going to reflect that this is supposed to be for longer than 25 years. So then, as Donna said, it would just be the deferred maintenance.
Okay, thanks. Okay, next one. Can associations with buildings of 2 stories still waive SERS component reserves?
So SERS does not apply to buildings that are 2 stories.
Okay.
Right. They only have to do the 4 things that they've always had to do, which is roofing, paving, painting, anything over, you know, $10,000 deal. And then the only change would be that you could still waive them. You just need that majority of the unit owners to do that.
Okay, and I think the next question we just covered there, any information regarding 2-story buildings, we did that. Anthony's question on windows and doors, is this including those that are unit owner responsibility?
I think that was clarified, right? That unless it was clarified that unless those the windows and doors are unit owner responsibility, then otherwise, then they must be included.
Okay.
Yeah,
Tony, can I take Mike's question? I get this all the time. Does association now have the ownership of the windows and doors? Clients get that confused all the time. It's not a question of ownership. It's a question of who has the maintenance and repair and replacement obligations under the documents. Let me give you a really quick example. The roof is common element. So technically, if you have 100 owners, it's owned in 1/100 by each owner. But that doesn't mean that the association doesn't have to maintain it. So people confuse ownership with maintenance and repair obligations. They're 2 different things. Somebody else can own it and the association can have to repair it, or vice versa. So.
Okay. Laura, back above there about the component.
With SERS, can we now use pooled funding on the SERS item? So if you have your reserves pooled, if those components are included in the pool, then you know, that yes, you could still use, I didn't see any prohibition on pooling
No.
reserves for the SERS components.
No, you can move non-SERS reserve items, like if you need to move money into the SERS categories. So say you've got a reserve account to retile the lobby floor kind of thing, but you realize, you know, you're going to need money for a SERS item quicker. You can move money that direction into the SERS from the other, but you cannot take SERS money and say, you know what? We don't need to do a roof yet. We still have a few more years. Let's go buy new pool furniture. You can't put it into that. You can't go the other direction.
You can't use SERS money for other items in the
Right.
pool. But yeah, so the question though is, right, can we use pooled funding on the SERS items? So yes.
Right.
Okay. Replacement of windows, the HOA responsibility. Again, the statute's not changing whoever's responsible for various components. I think we covered the next one. Items over 25 years useful life. Pooling, I think we just discussed that.
Yeah, there was Judy's question, somewhere down there where you said, can you repeat the 40-year inspection being able to count as the milestone inspection? So if you have done your 40-year certification, say, or, you know, you're Miami-Dade, that now can be used to if it's within, I think it's, you know, 24 months kind of thing, you can use that to say, you know, we did. And in fact, you can use that milestone inspection as the visual inspection portion of your SERS.
Okay, we're running short of time here. Anybody see anything else they want to quickly comment on?
The one Tara said about what are the consequences if the board does not comply with the SERS? Do we want to have an attorney take a stab at that?
Well, they don't, you know, that's a breach of fiduciary duties for officers and directors who don't, you know, if they willfully and knowingly don't get the SERS, the milestone or the SERS completed. So I'm not reading the question. I don't know exactly what it was, but
Yeah, I may not be seeing them.
So to answer this question, in light of Surfside, why would they eliminate the foundation? Okay, they didn't, because they added the word structure. Okay, so structure includes foundation. Again, more confusing drafting, but if you're talking about, you don't have a structure without a floor or foundation.
Right, they removed the words floor and foundation, but they just kind of defined it differently.
Right, and they added structure. So structure includes the entire shell.
Right.
What's difficult is some of these things, how would you actually get a reserve
Yeah, the
line?
25-year language was to kind of get towards that stuff again, there's a difference between fully funded and fully funding. And so when it's all, you know, predicated upon your structural integrity reserve study. And if your reserve analyst says, you know, this, it's not going away in the next 25 years, your foundation's fine, and they put 0 as far as, you know, money that you need to put in to replace it, then that's the amount that you have to have in that budget. And again, there's been a lot of questions by, you know, do we need all of this reserve money by December 31st, 2024? No, you just need the amount that is in accordance to your reserve study to get you so that in 10 years or how many years when you need it, you have it.
Okay. Somebody asked a question, are we going to touch on legislation dealing with voter referendums related to land development regulation? Travis, does that ring a bell? Was there?
Yeah, I mean, that's I mean, it's a local, a bill that would impact how, when and I don't remember the bill number off the top of my head, but that says when a vote can go and how that vote has to be conducted when it goes to your ballot for a referendum. You know, every year when we get, you know, when you go to the polls, or every other year and you get all of these referendums, it's going to impact how those how those ballots are, but I'd have to go back and look at it. But there was language that did pass that impacts, when and how that has to show up on the ballot.
All right. I think that's about it for now. We need to be respectful of everybody's time. I want to thank our panelists today. Thank all of those who've attended this webinar. We hope you found it to be of interest. As I mentioned, the recording will be available on FirstServiceResidential.com website in the very near future, along with the legislative alert. As part of our promise to provide exceptional service to our clients, we're continuing to be actively engaged in the legislative process, and we thank Travis for his time and efforts in the crazy world that is our state legislature up in Tallahassee. The battle is never over, and we're gearing up, as Travis said, for committee meetings starting in September, and a lot of these things that we've talked about, some of the things that didn't pass, next year's another year, so we'll be there and doing our part, and we encourage you all to be involved in the process as well. Again, a reminder, please talk with your association attorneys on the specifics of the new laws and how they will impact your community. Once again, we thank you for your time and have a great rest of your day.